Thank you, Mr. Chair, and I get up with a little bit of hesitation as this has had an impact in my riding, and it's one of those questions that that people have come and asked, why. And the Premier, one of her promises during her campaign was a Children's Serious Incident Review Team, and I can't help but ask, is this the response to the Serious Incident Review Team that we now have a child advocate, and are we trying to mesh the two together when in fact we haven't addressed the problem? And that's one of the questions, is this child advocate going to go back and review some of the serious incidents, and especially one of those here in the province that caused the death, tragic death of a young child that went through a very painful 60-day process, and this government failed to respond and protect an individual that needed protection, though there was day after day where someone should have stepped in. And again, after a one-year review of it, there's never anything come of the incident with baby Elizabeth. And when the paper finally broke the story after the ruling came out that it wasn't an accident, that it was abuse that caused the death, that was a homicide, this government now seems to be responding to that with this bill. And it's a great concern for me in the way that they're addressing this. It isn't adequate, and I don't know what they're going to do on, like I say, to do the serious incident review. But I just, for the record, Mr. Chair, want to go over a little bit of the process with baby Elizabeth and the 60 days that led up to the homicide, and how this government seemed to fail to respond to this very serious incident. And again, it's one of the questions in Bill 25 that I don't know that it's addressed yet, and maybe it is, that the proper sharing of information, and again, an individual who takes charge. But in early of March 2010, baby Elizabeth was taken to a drop-in clinic because she was fussy, and she was prescribed some medicine for ear infection. 2 to 4 days later, while babysitting, Elizabeth's paternal grandmother, Francisca, notices that baby is in pain and asks the mother to take her to the hospital. The child is taken to the hospital, and saying that her baby is fussy, doctors discover the baby's leg has been recently broken. The injury is recorded as a toddler fracture, which at that point, 5 days in, is certainly something that isn't unusual. And again, as the minister has been very eloquent in saying that, we don't want to interfere, but yet when the signs become evident, we need to step in. The injury, again, is recorded as a toddler fracture. Again, on day 13, at a follow-up appointment, an orthopedic surgeon, a doctor discovers that the other leg has recently been broken. No one contacts Children and Family Services. On March 15th, Elizabeth's grandparents called the social services response team with concerns about the baby's unexplained broken legs. The history on the file of the family shows that there's been a history of problems there. And the family also calls the Crime Stoppers to report suspicious of abuse and neglect. On day 14, CFSA supervisors assigned the case as an emergency investigation. This is 14 days in. The CFSA assessor interviews one of Elizabeth's half-siblings at school, then interviews the mother and another child at their Forest Lawn rental home. The other caregiver is interviewed, and a safety plan is made allowing only adults to look after the baby, not the other children in the home. On day 15, CFSA assessors attends the baby's medical appointment with the mother. The assessor speaks with the police child abuse unit, but no police investigation is initiated, with no complaint of inflicted injury. On day 20 or 21, the assessor attempts to have the child examined by Alberta Children's Hospital child abuse specialist. Day 22, the assessor talks with the orthopedic surgeon, who makes a referral to the hospital's child abuse specialist. A follow-up appointment is booked for 6 days later. Unbelievable. Here's a child with 2 broken legs. They have the experts coming in, and it takes 6 days. Day 28, mother and baby attend appointment with the child abuse specialist, where a full skeletal exam and blood work are ordered on Elizabeth. After learning of the family history, the specialist advises CFSA assessor to call police. A detective from the police child abuse unit is assigned to the case. Day 38 now, we've jumped 10 more days down. Skeletal examination results received back from the hospital from the child abuse specialist. The specialist, again 42, 4 days later, the specialist calls CFSA with the news that the child has 2 newly identified broken bones on her arms. The injuries are dated. After an internal meeting, CFSA assessor contacts the mother and the police and the child abuse detective. Day 43, CFSA assessor meets with the mother to discuss changing the safety plan so she is Elizabeth's sole caregiver. Day 45, police detectives interview the mother and the child's older half-siblings. Day 48, CFSA assessor, police detective, and hospital child abuse specialist meet to discuss the case. No notes are recorded. And this is the part, Mr. Chair, that is so frustrating to the grandparents who initiated this. They had offered to look after this child. There was a history of abuse in the family, and the paternal grandmother said yes, that she would look after this child. They went, they had this meeting, and there were no notes ever kept in that meeting. And you have to ask why. How do they have a meeting, and who are they trying to protect, this child or themselves? And this is why it's critical that we get a child advocate, so that these things can be addressed in an orderly manner and a time-efficient manner. That it is so just heart-wrenching for this family to have gone through 48 days at this point, and this child, one being jovial, happy, easy along with, crying, fussy, with multiple broken fractures. On day 49 through 58, the CFSA assessor has 3 telephone conversations with the mother. Day 61, again 3 more days later, Elizabeth is found unresponsive at the home by the police. She is rushed to hospital, where she is pronounced dead at 4:41 a.m. Her death is initially recorded as accidental. An autopsy later determined that she died from asphyxia. But, Mr. Chair, the story of baby Elizabeth is unacceptable, and the family is still very concerned that nothing has happened there. And earlier, it's interesting that the minister in his speaking says liability should be found in the courts. And this family has asked for an investigation, and the internal investigation has not ever produced anything on why there was no responses, why the team didn't work. There's been allegations that they have a quota. There's been allegations that, they've had other incidences. And one of the questions that the family has asked over and over again is to have a public review of this and make it public and show, and again, we understand that you don't need to bring the names forward, but what have been the previous 10 children that have been withdrawn and taken into government custody? What was the triggering points, and what caused them to take a child into custody to protect that child? Because this is a clear case, Mr. Chair, where looking back with 20/20 hindsight, you can only ask one question: why was nothing done? And we need to have the comparison. And so with this Bill 25, are we actually going to address, and will the child advocate go back and look at something like this and find some where the breakdown was? and we're going to fix the system so that we protect children in the future. There's nothing more heart-wrenching than to have one of these precious little ones that are being beat and abused, and everybody seems to know that, and yet no one takes action to do anything. And it's just wrong, Mr. Chair. How can we live in a society today where we say that we're so civilized and we're so politically correct, but yet we lose the life of a precious little one like this over, it just seems like bureaucracy, that it's not my job or it's someone else's job, the lack of communication, not able to bring people together immediately. And so going back to the Premier's statement that she wants a children's serious incident review team, is that another broken promise and we're just going with this new bill? Or is the child advocate going to be given that job, not only to be able to have a public inquiry or whatnot, but to be able to bring in a serious incident review team that is serious about reviewing something in a timely manner and not letting days turn into weeks, turn into a couple of months. But anyways, we certainly have a big hole here in this area. I hope that as this bill is passed, that the new child and youth advocate will look back at this, that it will be made public, so that we know what triggered, what caused these problems, and why there was no response. That's the hard part. I think most people in here have seen that video in China where that little child got ran over and 18 individuals walked by and didn't do anything. How callous can we become as human beings when it's not our responsibility, but yet I'm just ashamed to say that when I see what happened here are specialists that are all supposed to be at the concern of a child, and yet 60 days went by with multiple broken limbs and nothing done, Mr. Chair. And so I do, with all my heart, hope that this bill will set up for the future so that we respond in a quick and efficient manner. But yet I couldn't agree more with the Minister that we don't want to infringe on the family's rights. But when this type of abuse has taken place, and that question is there, and especially when it comes from family, this is the grandmother who looked after this child often and offered, and Children's Services called and says, would you take this child if we were to remove it? And said yes. And yet no action was taken when all of the signs show that there is a problem there. And now the other 3 children, after a year, have been taken from the custody of that parent. But it's just disheartening to see something like this happen in our province. And I truly hope that Bill 25 will address that, though we have many concerns that we're not sure that it really is going to be definitive and have that emergency response team. And again, the distance we hope will be presented there, that the Minister won't somehow be overseeing this as it seemed to appear in the case with the baby Elizabeth. But with that, I'll let others speak on this bill, and hopefully we'll do better in the future, Mr. Chair.
Thank you, Honourable Member. Are there any other speakers at Committee of the Whole for Bill 25? The Honourable Member from Edmonton Highlands, Norwood.
Thank you very much, Mr. Chairman, and I just want to indicate that despite some failures in the bill, some confusion which have been the subject of some amendments tonight, and which I regret were not accepted by the government despite their imminent good sense, that this is a good change. And this is in fact change that we have been pushing for and fighting for a number of years. And I'm pleased to see that the government has accepted and adopted the principle, which has been fought for by the Honourable Member for Edmonton Strathcona quite relentlessly, that the Children's Advocate should be an officer of the Legislative Assembly and not someone who is part of the management team of the Minister of Children's Services or the Minister of whatever the department is called at the time. I think that this is a very good change, and I'm looking forward to having a children's advocate that can strengthen our protection of children that can strengthen our awareness of the issues faced by children in care and by the people who are there to enforce and protect them. And I expect that this legislation will save lives, improve the quality of life of children who are in care, and make a difference for people. So I urge all members to support this legislation. Thank you.
Thank you. Honourable Member for Calgary-Glenmore.
Mr. Chair, I realize that there's one other question that I failed to get on the record that hopefully the Minister will answer, and to realize I certainly have no expertise in this area, just a concern. But my understanding is that BC's advocate was originally able to access Cabinet documents and report on problems that she found on how Cabinet was handling things. Is Alberta's advocate going to be able to access those documents so that we don't have to go forward to learn? We've got incidences now that need to go back that we can learn from. And in this bill, will the child advocate have that authority to go back and access all those records so that we can actually learn from our mistakes rather than having to repeat them again in the new position that's been put forward?
Honourable Minister of Human Services.
Thank you, Mr. Speaker. A number of items that the honourable member has raised in his previous comments and now in these comments, which I won't dwell on at length. Obviously, the situation with baby Elizabeth was a very tragic situation, and the least we can do is learn the most we can from that incident and make sure that we implement systemic and individual improvements to ensure that those sorts of situations don't happen again. That's the least we can do arising out of that very tragic incident. There was, in fact, a serious incident review team put in place and a report from that serious incident review, and many of the recommendations have already been acted upon, and I hope that we can continue to learn. The purpose of setting up the Quality Council and making it a statutory council as opposed to simply a ministerial order council is to make it clear that those serious incidents and deaths that happen need to be reviewed immediately, responsively, and we need to learn as much as we can. They should never happen, but let's face it, these are children at risk, and we will continue to have incidents, and we need to do everything we can to find ways to improve the system so that we don't have incidents. And so I want to learn as much as we possibly can, and I think that process has been undertaken. But there's nothing in the Act which stops the advocate from using past circumstances to look to enhance his advocacy and look for opportunities for learning from them and advise us as well on those circumstances. The honourable member mentioned in his last remarks and I addressed his concerns in my opening remarks. I won't repeat them all again, but I would just ask him to go back and read that, and then if he wants to have a discussion about it at another time, I'd be more than happy to do it. But I did go through sort of a litany of the authority that the advocate has under the Public Commissioners Act and the opportunities they have access to Cabinet documents in that circumstance. But I would indicate to the member, well, no, it doesn't have complete and unfettered access to Cabinet documents. But there are very few circumstances, in fact none that I'm aware of, where there is complete and unfettered access to Cabinet documents. But they do have the power to compel evidence and ask for information, and if it's appropriate to be released, then the decision can be made to release it. But what the honourable member indicated in his remarks was, in my view, a little bit of confusion, because Cabinet documents would not deal with the incidents that the honourable member is referring to. Obviously the minister would get advice with respect to if there's a serious incident or a death of a child in care. But under this Act, the information also will go to the advocate, obviously, and to the Quality Assurance Council for their automatic review. They won't have to wait for any direction to review. If there's information with respect to an incident, with respect to a child in care, a serious incident or death of a child in care, it automatically goes to the Quality Assurance Council under this Act, and obviously also goes to the child's advocate, and then appropriate investigations will automatically happen. So they don't need to mine paper in order to find incidents. Those incidents are, by law, under this Act, reported to them.
Thank you. Honourable Member Calgary-Glenmore.
Appreciate the Minister for helping to clarify that, but the point that I was trying to make is that this information has already happened in the past, and so is the new child advocate going to be able to go back and review what the Minister received, whether there was, I mean, to put it bluntly, Mr. Chair, the family feels that there had to have been political interference or something, because common sense said there should have been an action, and so to help clarify that up, it would be good to know that the child advocate can go back and look at those documents, and if there was something, they would bring it forward and show it. And so it's not about going forward, as the Minister's talked, it's going back. Is this child advocate going to have access to those briefings and the information that was given to the Minister, and if there's anything from the Minister to the former child advocate, I guess, at that time.
Thank you. Honourable Minister, do you wish to respond?
Well, Mr. Chairman, I think that's a very troubling allegation, actually. What I would say to the honourable member is that there was a very serious incident. It begged a thorough response. It got a thorough response. There was a team appointed to investigate it, and that team investigated and reported. The Children and Youth Advocate can continue to look at that circumstance if he wishes, certainly in his power to do so, to see that everything that can be learned from it has been learned from it. But I would say two things to the honourable member. First and foremost, again, as I said in response to Edmonton Riverview, and thanked him for his comments about the work that's done on the front lines, I don't think that there's any frontline worker who would put up with the type of interference that the honourable member is talking about. People might have made bad calls. There may have been a failure to exchange information appropriately. Those things we need to learn from and understand. But to suggest that there was some interference in them doing their work would be sinful.
Thank you, honourable member from Calgary-Glenmore.
Maybe interference isn't the correct word, and again, I haven't read that report that came out, but whether it's case overload, I mean, when you go through this case, there's just problems there that shouldn't have happened, and the family is extremely disappointed in the way it was handled, and still, like I say, they feel that there needs to be more information given out to how no decision was come to over 60 days. And so whether, you know, just the honesty that say, look, there was case overload and they couldn't address it for 10 days, though it was critical, and to show that, look, there's these other ones that we saved. I mean, this is a very serious, tragic accident or incident, and yet they're really, to the family's knowledge, that there is no explanation when, and so their question is what information, how was there not a decision made, something went wrong, and yet that's never come out, and that's why looking back is so important for them to understand and to learn more, and again to have that open vetting, I guess, Mr. Chair.
Thank you. Are there any other members who wish to speak to Bill 25?